All right, we're ready to proceed with the next case, Osceola County versus Kissimmee-St. CLOUDJAYCEES. Morning, Counsel.
Morning, Honors. If I could reserve 5 minutes for rebuttal?
Yes, sir.
Thank you. My name is Frank Townsend. I represent the appellant, Osceola County, Florida. The county has brought this appeal seeking the court's review of the contract at issue between the parties regarding the placement of bus benches in the county's right-of-ways. The county asserts that the lower court incorrectly ruled and interpreted the contract and misapplied the law regarding indefinite contracts, and therefore ruled that the provisions of the county's ordinances, which had terminated the contract, were invalid.
How do you distinguish this case from the Gainesville University of Florida case, for example, or the Florida Keys Water Authority case? I mean, those seem to be pretty supportive of the other side, so help me distinguish those.
I agree. They do seem supportive of the other side. However, the main way to distinguish those cases is the fact that in each of those cases, the City of Gainesville, Daytona versus Stansfield, and Florida Keys, was that the fact that the terminating party in each of those cases retained a benefit, a continuing benefit after the termination of the contract. Whereas in the instant case here, when the county terminated the contract, there's no continuing benefit. The bus benches are owned by the appellees, and they would continue to own them. They would remove them, presumably.
Well, is the focus, though, on whether the benefit continues after termination, or is the focus on whether there's any benefit during the renewal periods to give it consideration on both sides of the deal? So that it's not just a unilateral benefit to them, there's a benefit to the city during these 10-year renewals. Yes,
during the 10-year renewals, the contract was initially entered into in 1981. It renewed in 1991 and again in 2001. Throughout that time, there's no dispute that the county benefited from having the bus benches in its right-of-way. The county's not taking issue with that. However, what distinguishes the three cases from this case is that those cases, once they were terminated, the terminating party would retain the benefit. For example, the City of Gainesville, the University of Florida would remain in Gainesville after the termination, but the city would no longer be obligated to supply the water at the reduced rate that was negotiated. Again, in this case, in the instant case, the bus benches are removed. The county would no longer benefit from having the bus benches there, and that was the county's choice. They no longer wanted to be bound by this contract. But the material facts of this case are basically contained in the contract itself and the ordinances that terminated it. There's no issue as to the facts. The lower court did not have to resolve any disputed facts, and the parties in their briefs agree that an indefinite contract is terminable at will. It was just the controversy, and where the lower court erred was interpreting this particular contract not to be terminable at will and not to be indefinite. And that's what the narrow issue here before this court would be. The county's position, of course, is that this is an indefinite contract and that the county did not have to prove any type of default in order to terminate the contract. And that's supported by the plain reading of the contract. It reads, as we briefly discussed, that if there's no action taken by any party, it doesn't say no action, but it says the contract would automatically renew after every 10-year period. There's no definite duration specified in the contract. There's no date specified to when the contract would expire, and there's no readily ascertainable event which one could look toward in the future and say, okay, when that event occurs, then the contract will naturally expire.
Well, wouldn't the ascertainable event be a breach on their part? They don't provide benches, or they have lousy benches that are unsafe, or they stick them in the right-of-way, or those are ascertainable breaches, and those events, I think everyone concedes, would allow the county to terminate.
Yes, Your Honor, those are for lack of a better term, non-performance events. And that's the appellee's position in this case, that if they fail to perform, then the county can terminate the contract. And there's a few problems with that as to why that argument would not hold up. And that is, number one, that in the contract itself, the remedies for a, lack of a better term, a misplaced bench for a variety of reasons, are found in paragraphs 4 and 7 of the contract. And it basically, those two paragraphs essentially read that the county can order the removal of a bench, should that bench be in violation of for some reason. But the paragraph 10, which the appellees cite to as being a determination provision, you don't get to paragraph 10 because paragraphs 4 and 7 provide you the remedy to remove a bench. So if the county were to say, this bench is invalid, it's placed wrong, or it's dangerous, we terminate the contract, the argument would be, no, you can't do that. Paragraphs 4 and 7 says you can just order us to remove the bench.
Well,
So
the breach then is if they refuse to remove the bench, then they've breached the contract, and I think you could terminate. I mean, I agree that it would be illogical for them to do that.
right. Well,
But I'm just trying to understand, I mean, your argument is, you know, that the contract gives them an opportunity to cure if you think that there's a default, and if they avail themselves of that opportunity, then the contract would continue, but if they fail to take advantage of that opportunity, that's when the default occurs.
Respectfully, I disagree. Paragraph 7, it says if Metro fails to remove such a bench, then the county may remove same at the expense of Metro. So it's not, doesn't say if they fail to remove it, then we can terminate. It says if you fail to remove it, the counties can remove it and basically send them a bill, and then that becomes a different issue. But that's to my point that paragraphs 4 and 7 remedy the misplaced bench. And paragraph 10 admittedly says that it's a termination for cause provision. But that's different than a readily ascertainable event, such as in some of the other cases that the appellees have argued in their answer brief, starting on page 12. Besides the three cases that we already discussed, they argued Douglas versus City of Dunedin, and in that case, that was a contingency contract where the readily ascertainable event, or the contingent event which was to occur in the future, would trigger performance by the other party, whereas here, the event in the future, namely the non-performance by the appellees, would trigger default. So that case is distinguishable and doesn't support their argument against the county's position that it's an indefinite contract and therefore terminable at will. Similarly, in the Interactive Services versus the Heathrow case, which was cited by the appellees, that dealt with the construction of a number of homes. And again, I don't recall the exact number that was to be constructed, but if you say construct 3,000 homes, then and you don't say when to construct them by, well, that would not necessarily be a terminable at will contract, because once those 3,000 homes are built, that's the readily ascertainable event, which would then terminate the contract. Again, the two other cases they cited to dispute the county's position here was the Orkin case, which the court found that the event which triggered the termination of the contract, which was when home repairs were to be done on the house in that case, was an inevitable event. Here, what we have, non-performance by the appellees, is not an inevitable event. Could they fail to perform at some time in the future? Sure, maybe, maybe not. But will they definitely default at some time in the future? No, no one can say they will definitely default. So therefore, this contract essentially renews over and over and over and over again at 10-year periods indefinitely. And then the Rigera versus American Distilling case, that case basically stands for the proposition of reasonableness after reaffirmation. And basically, after a party reaffirms a contract that appears to be a perpetual contract, it should remain in effect for a reasonable period of time. And the county, I would submit to you, did that. If you say that the 1991 was a reaffirmation, in 2001, the county, again, for lack of any notice, the contract was reaffirmed. And then in 2009, 8 years into this third 10-year period, the county gave notice that in 2011, the contract would be not renewed and to be terminated. So the county did act in accordance with that proposition, that it acted in a reasonable manner after the second reaffirmation of the contract. I cited in the initial brief to the Bales versus Journeyman Barbers case, and although that is admittedly not the same factual case, I dealt with a barber and a barber union. This is a bus bench case. I cited to it to illustrate that it had a very similar renewal language. In that case, it was a one-year contract, which continued on for similar periods after that 1 year. What the Bales court ruled was that you had a definite contract for 1 year, and then after that it became terminable at will. And the county would submit to the court that is a correct interpretation for this instant case, that you had a 10-year term starting in 1981 when this contract was first signed, and then after that, the contract as a whole became indefinite. 10-year renewal periods, but indefinite overall. And after that initial 10 years, it became terminable at will. Alternatively, the county would submit that the court could lawfully interpret the contract to be terminable at will at any time after it was first executed in 1981. Terminable at will upon reasonable notice. The contract was in effect for better part of 28 years, and then the county gave 2 years' notice that it was not going to be renewing the contract. Therefore, the county respectfully requests this court to determine that the contract was in fact an indefinite contract by its very nature and terminable at will, and that the county's ordinances terminating the contracts were in all respects valid and enforceable. And I know I have some additional time, but I just reserve that for rebuttal.
Thank you, sir.
Thank you.
Good morning.
Morning. May it please the court, Todd Pittenger with Ackerman LLP on behalf of the appellees, Metropolitan Systems, and the St. Cloud KISSIMMEE-JCs. The trial court correctly determined by virtue of its summary judgment ruling that the ordinance created, and both ordinances created an unconstitutional impairment of contract, and the agreement is not indefinite. The trial court was correct in making that determination. So we would suggest that this court should affirm. I would differ in the suggestion that all of the facts of the case are appropriately set forth in the contract. The 1981 contract is the focus of this appeal, but the court's summary judgment had other facts included in it that were in no way contested by the appellees, and so this court can also consider those facts. Those facts came from the ordinances themselves, the contents of the ordinances, and from the unrebutted affidavit of the affiant, Mr. Rocker, who had put forth the situation supporting our impairment contentions. If you look at the contract from an overall standpoint, what it memorialized is what was a 50-year civic project that the Metropolitan Company had given to Osceola County with the association with the JCs. And the consideration, as the court observed in questions directed to the county's attorney, the consideration was ongoing. It wasn't just simply the providing of the benches. There were 130 benches installed by my clients. They were maintained ever since 1981, regularly. That was one of our contractual obligations. So the county continually received a benefit. The whole purpose of this contract was to provide comfortable seating for members of the public. And the exchange, the quid pro quo that my client and the JCs received, was the ability the right, privilege, and license to lease advertising space on those bus benches. They don't all have advertising on them, as the record reflects. Some just have the name of the charitable enterprises that are associated with my clients to give those charitable enterprises some name recognition. But that is a right that the county conferred on my clients, and that right continued. And that is a benefit that was under the contract. They were entitled to a reasonable expectation that that would continue as long as they weren't in default under the contract.
Counsel, did I hear you say something at the beginning of your argument that this was a 50-year civic project?
Yes, Your Honor.
What's the genesis of the 50-year?
The contract actually preceded the project, the civic project, as recognized in the court's judgment and as recognized in the contract itself. It preceded the actual 1981 contract by literally decades, but the county decided to memorialize, and it was requested by my client back at the time, and this is what the declaration supporting the summary judgment reflects, that what had already been a civic project that was ongoing be memorialized in writing, and it was approved by the county commission unanimously by an ordinance when the 1981 contract was signed. So it became, at first it was a civic project, it became a contract in 1981. And by ordinance, I mean...
You don't suggest, though, that the contract then had a 50-year term?
No, not at all, Your Honor. I would take issue, though, with the notion that there's no duration. Counsel for the county had indicated that the contract did not have a duration provision. Well, it does in paragraph 9. It says it has a 10-year term. That's the duration. It then goes on to say, so long as Metro performs as set forth in the foregoing conditions, that's the ascertainable event that was discussed in earlier questioning, then such rights, privileges, and licenses shall be automatically renewed for similar periods. So it's subject to renewal for 10-year periods based on the ascertainable event, which is that we, Metropolitan, are not in default with the obligations under the contract. And the obligations are not just the ones that were set forth in the argument from the county's attorney. We have to place the benches in a way that they don't obstruct passage along any public right-of-way or create a hazard or otherwise be detrimental to public safety, welfare, morals, or health. That's in paragraph 3. There are design criteria in paragraph 4. Several prohibitions. There's criteria for how large the advertising can be and what the size of the bench should be. And in paragraph 5, we have to maintain the benches in good and substantial state of repairs. We have to maintain liability insurance. There's all these obligations that the county contracted with us to perform. And if we were not to perform those obligations, then we would not be meeting the specific ascertainable event that is referenced in paragraph 9 and also in the term provisions. So based on 9 and 10, that's how this contract can come to an end. The rules of construction, as this court is well aware, are to construe a contract to be valid, not invalid, to give effect to all of its terms.
Well, every perpetual contract presumably could be terminated in the event of a material breach by one of the parties, right?
It could, but we have more than that here because we have an obligation to not be in default.
Well, every contracting party has that obligation, don't they?
But here it's specifically set forth that we have to perform all of the conditions in the agreement. So if we are not doing that, then the county would be within their rights to say, your contract is ended because you failed to maintain the benches in substantial workmanlike condition or any of the other conditions set forth in the contract.
If the contract, instead of having renewable 10-year terms, simply said this contract will continue in perpetuity unless a party materially breaches it, would that be an enforceable contract?
That would be a problem because it would have used the words in perpetuity, and the court...
Why isn't this in perpetuity, since the only way it can be terminated is on a breach, which can terminate any contract?
Because it has a 10-year duration, and at every 10-year interval, the county, if it decides, in the hypothetical the court had, at any point the county could claim we were in default and trigger the default provisions in paragraph 10 and the notice and opportunity to cure provisions. But at every 10-year interval, which is not perpetual, they can look at it and say, did Metropolitan meet its obligations under this contract? If it didn't, they could say our contract was over. That's an independent, ascertainable basis.
They wouldn't have to wait 10-year period to do that, right?
No, well,
Presumably at any point in time, they could do that.
At any point, they could declare default. They go into the court's hypothetical. Just like in any contract, you can try and declare default. But at every 10-year interval, we have the burden to not be out of compliance with the contract.
100-year intervals rather than 10-year intervals.
Well, then it
Problem?
would, no, that would not be a problem, because that's ascertainable.
1,000-year intervals, no problem.
That would not be perpetual, and so it's ascertainable. I mean, the county, the most sacrosanct obligation of a governmental entity is its contract. I mean, the contract clause is something that the government has to comply with, and those are the most suspect types of constitutional violations when it's the government itself trying to alter its own contractual obligations by an ordinance. This contract was adopted by a unanimous ordinance. Well, with the unanimous ordinance, actually two ordinances, in 2009, they sought to unilaterally terminate the contract and also modify significantly the terms of that contract. I mean, it was never challenged by the appellee, either here or with the trial court, but the notion that there is impairment here, because impairment is absolutely established. They put this out to competitive bidding, even though there's a statute in Florida that we cited in our briefs that says these contracts for placing bus benches in right-of-ways are not subject to competitive bidding. They're specifically exempted from the Florida legislature, and that's established Florida law and shows the policy of the state. They negate our contract, they declare it terminated unilaterally, they put it out for competitive bidding, they impose a permit obligation, they impose ongoing fee obligations, they impose extensive application process that requires a survey and all this cost. They regulate with design standards, they require additional waste receptacles, and they have maintenance standards that are different than those in the agreement. So they are unilaterally modifying the agreement. And all we have to do is look at the ordinance to see that they've done that, because they have a grandfather clause in the ordinance, 09-14, which says they hereby ratify our contract all the way up until when they've declared to be the expiration, which is December 13, 2011. Then they say that we're over and that all of our benches have to be removed unless we comply with this new ordinance, and they give us then 30 days to do that. And they say we have to apply for permits and all the rest. We had the contractual right to have all that there without this ordinance. That's why the constitutional challenge that was brought here was an as-applied challenge. We didn't seek to invalidate the ordinance as to everyone else. We sought to invalidate it as to Metropolitan because we had a pre-existing contract, and the county had given up its right to regulate us in derogation of the terms of that contract when it entered into it. It's bound by the contract because of the contract clause. So this is not the situation in a lot of the impairment of contract cases where the argument is that a statute or ordinance is passed and there is a collateral effect on third-party agreements. We're talking about an agreement that the county itself is the party to, which is the most suspect type of impaired contract agreements. There's a case from this court, Judge Antone, when he was on this court, authored it in 1997 that we cite in our briefs, Brevard County versus FPL. And that case entirely rejected the notion that the county's police power, it was Brevard County in that instance, somehow gets it out from under being required to honor the contract clause of the Constitution. So you cannot, they're not exempt. They can't use the fact they're a regulator to get around their contract. And recently, although this isn't cited in our briefs, the constitutional issue presented here is a difficult one for us because the county did not preserve it from our standpoint in its summary judgment briefing or in its argument at summary judgment. They really, just like they did before here, simply based their attack on, or defense rather, of their ordinance and our attack on that ordinance on this notion that it's not perpetual. That was the county's exclusive argument. So for the first time in their initial brief on appeal, they suggest in sort of a side issue in one of their later points that they are supported by the fact that they have to exercise the police power, that they have the right to do what they did here. They still, even through the reply brief, haven't really taken on the impairment issue. They haven't argued these constitutional cases that say that some standard hasn't been met to support an impairment of contract analysis. But because we're here and we don't want to be sort of sandbagged, for lack of a better word, by application of that later when they haven't even preserved it, I feel like if the court wants to address that, we can. But I would just call the court's attention to the recent 2013 Florida Supreme Court case, Scott versus Williams, which says that government's significant impairment of its own contract is not justified by necessity if the state could have adopted alternative means of achieving its goals without altering the contract rights. They have clearly altered our contract rights, and it is an unconstitutional impairment, and they are retroactively applying it. And how you look at that as an enactment is retroactive, it if attaches new legal consequences to events already completed. We had put the benches there. We expected the benches to be continued to be there. We were maintaining them based on the standards that were in the contract. And this enactment of the ordinance unilaterally changed that. I mean, if the court were to permit this, then no county contract or municipal contract would mean anything, because they could just, a different commission could decide, let's change this or end it, and enact an ordinance, and it would be over. So I think it's telling that the county hasn't really opposed us on the impairment issue, because impairment's clearly established. And in the Florida Supreme Court's Pomponio case, how they define impairment is to make worse, to diminish in quantity, value, excellency, or strength, to lessen in power, or to weaken. It clearly is that. So you have impairment here, you have retroactive effect applied to an existing contract, which turned what was a good contract for Metropolitan and the J.C.'s into a losing proposition. All of a sudden, it's competitive bidding, we don't have a contract that means anything, and they've declared it terminated. So their argument, I would just suggest that, in the two Childs cases we cited as well in our briefs, that the right to contract is one of the most sacrosanct rights guaranteed by, Article 1, Section 10 of both the Florida Constitution and the United States Constitution. And the county is severely limited in its authority to change its contractual obligations that itself created. So they have in no way made the case that the trial court committed error there. And as far as this agreement being terminable at will, it is not for an indefinite period of time. There is the duration provision. As the court observed in questioning with the county attorney, the City of Gainesville case is very instructive because there the contract was conditioned on the happening of an event. That event was that the University of Florida remain in the City of Gainesville. And the Florida Supreme Court noted that although the location would seem to be permanent, we don't indulge the clairvoyance that it will be perpetual. Pompeii was permanent, but history records that it was not perpetual. I mean, that's why, in response to the earlier question, I suggested 1,000 years isn't a problem. I mean,
his argument to distinguish those cases is that, in the Gainesville case, for example, that if Gainesville stopped supplying free water to the University of Florida, the University of Florida would remain in Gainesville, and the city would get the benefit of having the university there, but wouldn't have to give it free water as it had agreed. He distinguishes that by saying that if they terminate this agreement, you get to remove your benches. There's no continuing benefit after the contract ends, whenever that is, unlike the fact that the University of Florida is going to stay there after, if Gainesville stopped supplying free water today, presumably the University of Florida would find either an alternative source or buy water from Gainesville. Just like the Navy base down in the Keys. The Navy base was going to stay even if the Keys Aqueduct Authority failed to provide them with water at whatever rate they had agreed, or free, or whatever it was. So there was a benefit that continued after contract was over, whereas here, if they terminate the contract or it tinkers out on its own, you pick up your benches and go away. Is that a distinction, and if so, is it a distinction with a difference or is without a difference?
I would suggest they have not in any way raised a distinction, nor is it applicable here, because the county has received a benefit. It's an ongoing benefit from having those bunch benches
I
there.
understand that while the contract is in effect, and while the benches are out there, I'm willing to accept the idea that that's a continuing benefit to the county. What I'm trying to focus on, though, is if the contract ended today, and you went out and picked up your benches and sailed off into the sunset, what continuing benefit does the county get at that point?
Well, they would have then unilaterally changed the contract terms, because we were entitled to rely on the notion that as long as we continued to meet it, we could have our
What I'm trying to
advertising
focus
there.
on is the idea of whether this is or isn't a unilateral contract. And he says that the UF case and the Keys Aqueduct case are distinguishable because in those cases where the beneficiaries of the contract, University of Florida and the Navy base, were to get free water as long as the Navy base stays there and as long as the University of Florida stays in Gainesville. So unless the city cuts them off and they pick up and leave, which is unlikely, they're still going to be there. So the city continues to benefit from having the University of Florida produce the ancillary benefits that having a big employer like that produces. What benefit continues to the county if you pick up your bus benches and take off?
I would suggest two things. One is that there is no continuing benefit requirement, so he is misreading what those cases actually rested
Well, and that's
upon.
why I asked you if that distinction makes any difference
I
in the
don't-
analysis of the holdings of those cases.
I don't think it does make a difference. And the reason is that we were entitled to the benefit of the bargain we struck, which was to have these benches there for as long as we continued to perform. And they would be unilaterally, they would be changing a bilateral contract that had give and take on both sides into something that they could unilaterally terminate at their whim, just by convening a commission meeting and deciding, despite the fact that you've given decades of benefit here, it's over, you're done, we're now going to go make revenue off this. That's the other thing that's not challenged at all in the record below, that the whole goal for the county in enacting this ordinance, although they have a lip service reference to public safety and welfare in the preamble to the ordinance, they don't have any substantiation of what that might be. They just have a wherefore clause that says we're doing it in the interest of the public.
All right,
But it was to
counsel.
get permitting fees. It was
Exhausted
to,
your time.
Thank you,
Thank
Your
you
Honor.
so much.
Thank you, Your Honor. Regardless of whether you're a government authority or an individual, you can't impair a contract that you lawfully terminate, an indefinite contract that you have lawfully terminated. Termination is not a legal impairment that would to render that action illegal or invalid. The county obviously brought this appeal because it disagreed with the lower court's ruling and its negative effect on the validity of those ordinance provisions and the county's ability to control its own right-of-ways for the benefit of its citizens. But if you take a step back out of the realm of bus benches and just look at the legal issues presented to the court in a broader sense, if the lower court's ruling is allowed to stand, and if the appellee's argument is to be taken, then this court's ruling would greatly impact the law of indefinite contracts everywhere, not just as it applies to the county, not just as it applies to government agencies, but as it applies to individuals. The appellee's argument is essentially that if a contract has no specific end date and it does not have a readily ascertainable event that the parties can rely on to know when that event occurs, the contract will terminate, then the contract nevertheless would still not be indefinite. That's their argument. It would not be indefinite And that would, simply on their rationale, that a party could choose not to perform. So non-performance would be the only way to end that contract. And
But it would be fair to say that the result of this ordinance, if it's upheld, is for years, you all had a contract where they provided a service, and you didn't have to pay for that service, but in return, they got to get advertising revenues. And if your ordinance goes into effect, then either them or their successor provides that service, you don't pay for it, but you get to share the revenues now. That's the practical difference here.
that's the argument, Your Honor.
You're just trying to unilaterally change the contract so that you get more money than you did before.
That is certainly their argument, and the county admittedly, we paid nothing. The bus benches were present. They retained the revenue from whatever revenue that was. It's not part of the record. Presumably there was from the advertising. The county did not take any share of that. Under the ordinances that were passed in 2009 and 2010, in addition to the requirements of any new bus bench provider or the appellees, if they were to continue on, the county would be charging a fee for each bus bench that's in place. And that fee is, one person could say it's coming out of the revenues. Of course, it has to come from somewhere, but it's not really
That's the only place it could come from.
Yeah, naturally, it only could come from the revenues if there were any. But the fee is also for the regulatory costs of regulating the county's right-of-ways, which the county has a duty to do that because its citizens use the right-of-ways. That's a cost to the county. In 1981, it was 30-some years ago, the population was a lot smaller in Osceola County. The infrastructure was a lot less. The bus system was, I believe, non-existent. But nevertheless, it was a lot smaller place. The costs were a lot less. We're now 30-some years later, and the county saw a need to protect the public's welfare to update its requirements. And in doing so, it realized it had this contract that was still on the books, and it looked at it and said, we're not going to let it renew for another 10 years. We're not going to terminate it right now, right this minute in 2009. We're going to give the appellees 2 years notice. We believe that's to be reasonable. And then we're going to terminate the contract. And under all the case law, the law of indefinite contracts, that's what they should have done. That's what the county did, and that's what should have been done. But to rule otherwise,
Doesn't Section 337-408 give DOT already the authority if they think that there's a bench that's creating a danger to the public or messing up with the right-of-way, they can tell the vendor or the county, take care of the problem, either remove it, move it, do something to solve the safety problem?
that appears to be what the statute does say. There's nothing in the record to indicate that the DOT's ever done that. I don't know if they have or not.
Because DOT's asleep at the switch, or it could be that none of the bus benches are a safety hazard.
That
I don't know
could
what
be.
to draw from that, but the power nonetheless is there, that there is a regulatory body that can prevent safety hazards from coming into effect.
It is. There is. The DOT does have some regulatory authority there. However, it's also the county's duty. It's the county's property. The county's duty to protect its citizens in the right-of-way, and the county acted to do that. And quite frankly, that argument, although it is a interesting issue, it doesn't necessarily affect the law and the argument as to whether this particular contract is indefinite and whether the county, despite the fact that the county is a government, or if it was a contract between individuals, the law would be the same. It's an indefinite contract, and therefore it was terminable at will upon reasonable notice to the other party. And the county would respectfully ask this court to issue its ruling and interpret the contract consistent with that existing law.
Thank you, counsel.
Thank you. Thank you, Your Honors.
Thank you both.